Warm greetings everyone. In this video, I'm going to explain what is winding up of a company. At the end of this video, we will be able to define what is winding up of a company, difference between winding up and liquidation, different modes of winding up, and what documents are required for winding up of a company. Winding up is a legal process in which all the assets of a company are sold and liabilities are paid off. After that, if any surplus money remains, it will be distributed to shareholders in the proportion of their shareholding. It is a proceeding by which a company is dissolved and it represents the last stage of a company's life. Now let's discuss who are entitled to apply for winding up of a company as per Companies Act 2013. Section 272 of the Companies Act 2013 clarifies about the list of persons who shall be entitled to apply for winding up of a company. First, the company itself can apply for winding up by passing a special resolution in a board meeting where minimum 75% approve of winding up of the company. Next, any contributory or contributories. On commencement of winding up, the shareholders are called contributories and they are liable to pay for the uncalled shares of the company. Next is the registrar of companies. Even the registrars of companies is entitled to wind up a company. Uh, Next, any person authorized by the central government in that behalf for winding up of company as per section 243 of the Companies Act 2013. And finally, the official liquidator. The official liquidator can be or may be appointed by the company itself, by the government, or by the decision of a court. Now, let's discuss about the difference between winding up and dissolution of a company. First, let us understand what dissolution is. Dissolution means if a company ceases its existence and its name is removed from the registrar of companies. After dissolution, the company cannot sue or be sued, cannot enter into any contracts, nor a third party can file a liability claim from the company. Meanwhile, winding up is the first process to be followed when dissolving a company. Company remains in existence when it is winded up. During winding up, third parties can file a claim and the company can sue or be sued. Now let's see what are the different modes of winding up of a company. A company can be wound up in three ways. They are compulsory winding up by the court, voluntary winding up, and winding up under the supervision of the court. First, let's discuss about winding up by court. A statutory meeting is not conducted in 3 to 6 months after issuing shares, then company is wind up by rule. If company has not conducted annual general meeting in 2 consecutive years, then the license of a company is cancelled by rule. If company doesn't start their practical work from the next day to 1 year after getting the commencement certificate, then the license of the company is cancelled. If any company does not satisfy the minimum limit of directors at any time, then the company is wind up at that time. That is, Section 149, Subsection 1 of the Companies Act 2013 requires that every company shall have a minimum of 3 directors in case of a public company, and two directors in case of a private company, and 1 director in case of a one-person company. In private limited company, director becomes if the director number of directors reduces to 1 from 2, then the company winds up at that time. Second, let's discuss about voluntary wind up. There are two types of voluntary wind up of a company: members voluntary wind up and creditors voluntary wind up. In members voluntary wind up, directors call for an extraordinary meeting where minimum 75% have to approve for specific resolution passed in the meeting for winding up of company. And in the case of creditors winding up, the directors call for an extraordinary meeting on the request of the creditors. Then uh, the company prepares and submits the declaration report. After that, directors appoint liquidators, and liquidators assess the value of all the assets and liabilities, and sell all the assets on the market value of the assets. After liquidators assessing, final meeting is liquidators call for final meeting and present report to directors and shareholders. Lastly, let's discuss about supervision of court. Resolution for winding up is passed by members in the general meeting. Liberty is granted to creditors, contributors, and others to apply to court for some relief. The court may also appoint liquidators in addition to already appointed, or remove any such liquidator. The court may also appoint the official liquidator as a liquidator to fill up the vacancy. Liquidator is entitled to do all such things and acts as the liquidator thinks best in the interest of the company. He shall enjoy the same powers as if the company is being wound up voluntarily. The court may also exercise powers to enforce calls made by the liquidators and such other powers as if an order has been made by the winding up of the company altogether by the court. Finally, let's discuss about the documents required for winding up of a company. A company needs certificate of incorporation of the company, memorandum of association and articles of association of the company, certificate related to the closure of bank account of the company, copy of the board resolution, copy of the resolution of the creditors stating that the three-fourths of the members or 75% of the members have accepted for the winding up of the company, statement of accounts of the company, winding up petition form Win 1 or Win 2, statement of affairs of the company in the format of Form Win 4, affidavit of concurrence in format of Form Win 5, advertisement in the vernacular newspaper Form Win 6, appointment of provisional liquidator in the format Win 7 and Win 8. We have reached the end of this video. In this video, we discussed about what is winding up of a company, difference between winding up and dissolution, different modes of winding up of a company, and finally, documents required for winding up of a company. Thank you.